what the screaming memes on the left are saying that, oh, well, the president can just assassinate people. Well, no, it's not a core function of the presidency to assassinate someone. That on the other hand, to the extent he has to make tough decisions about how to conduct a strike to eliminate a terrorist threat, he's absolutely authorized and protected to make that decision.
Well, there's only been one president in American history that I know of that's drone striked American citizens, and that is Barack Obama, right?
Let's go.
Welcome to Citizen. We got a special guest today, the Attorney General of Missouri, Andrew Bailey. How's it going, sir?
Hey, good afternoon. How are you?
I'm living the dream, and nobody who says that means it. I think you know that. You were in the Army for a while, so let's get right into it. Where did you grow up? Are you a Missouri native?
I am. Yeah, I grew up in Columbia, Missouri. Graduated from high school there, and then attended the University of Missouri on an ROTC scholarship back in 1999. Always planned on going to law school, but 9/11 happened and those plans changed. So volunteered for a combat arms branch service. Was assigned to Armor Branch of the U.S. Army after I graduated, and was trained on the M1 Abrams main battle tank, reported my first duty station, and volunteered to deploy to Iraq with the 3rd Armored Cavalry Regiment. And when I met them overseas, we were stationed in the Nineveh province up in northwestern Iraq, and I was assigned as an Armored Cavalry Scout platoon leader.
Sweet. So you were, what is that, 19 Alpha?
19 Zulu. Yep.
Zulu,
19,
okay.
Yep.
What's the difference between Alpha and Zulu? I don't know what Zulu is.
Yeah, I think Alpha is just straight Armor Branch, and Zulu is cavalry.
I see. So you were at 3rd ACR.
Yeah, stationed up in Nineveh province as part of OIF 3. You know, we had just a troop-sized, company-sized FOB up in the Nineveh province, and so it's 180 American soldiers, all male at the time. And we were training the Iraqi army, training the Iraqi police, training the Iraqi border patrol, and then conducting cordon and search operations. We secured the province we were in for the constitutional referendum, screened the Syrian border, and also my platoon was selected to participate in the largest offensive operation of 2005 to reclaim the city of Tal Afar, Iraq. So part of that operation as well. Had 6 Bradley fighting vehicles, around 30 soldiers, and usually 2 platoons of Iraqis as well.
Yeah, my guys were with you, I think. That was right before I got to the 82nd, but 2325 is where I was with the 82nd. I think they were attached to you guys for that Tal Afar operation.
Yeah, absolutely. I remember we definitely chewed some of the same sand.
Sure, yeah. So what was, my deployment time was from during the surge, 07 and 08, so I didn't really get around too much in 05. What was it like in 05?
It was still, especially in the where we were stationed, it was still very rustic. Again, living in tents with dirt floors. When it rains, everything turns to mud. Scorpions are crawling up the walls of the tent. We didn't have hot chow all the time because we were at the end of the supply chain, and so hot chow and showers were a real commodity when you could find those. And there was still a real sense of, working in partnership with the Iraqi Border Patrol, Army, and police force to try to train them and get them up to speed so we could hand it off to them. And there was still a level of optimism at that time that eventually we would be able to get them to a state of competency to be able to hand the battlefield off to them. And so that was really that transitional moment. I completed that deployment, came home, and then redeployed a second time as kind of at the tail end of the surge from 07 to 09, and was in Key West, just south of Mosul, on the second deployment, and worked my way up to an XO and then ultimately a troop commander during the second deployment.
And then at what point did you go to law school? Because did you do that after you got out of the military, or how did that work?
Yeah, got out after my second deployment, and I actually moved to the city of St. Louis, and I worked as an armed guard at a courthouse up in North St. Louis City, kind of a rough neighborhood. So I went from commanding 13 platoons in Iraq to wearing a revolver, working the front door of the courthouse, applied to law school, went back to University of Missouri on the post 9/11 GI Bill. Was really fortunate to have that opportunity, have my school paid for on the front end with ROTC and on the back end with the post 9/11 GI Bill.
Yeah. So work your way through grad school, and then what happens after that?
So I graduated from law school, and all I ever wanted to do was be a prosecuting attorney. My grandfather worked in law enforcement. He used to take me to court with him to watch him testify. So I grew up thinking working with police to lock bad guys up was about the coolest job on earth. And I was an assistant prosecutor at the Attorney General's office for a couple of years, traveled the state doing special prosecution all over the state of Missouri. Got to go into some really cool courthouses, worked with some really great law enforcement agencies. But I'd married a gal from Texas that I met when I was stationed in the Army down there at Fort Hood. And she was ready for me to be home at night, not traveling the state. So we ended up in Warren County, Missouri, just west of St. Louis. And I was an assistant prosecutor there. In Missouri, state law is enforced at the county level. So it was a great opportunity to engage and plug in, tried numerous jury trials, worked with law enforcement, worked locking bad guys up, finding justice for victims, keeping your community safe was something I really valued. Would have done that the rest of my life. In a third-class county, you have a couple different jobs as an assistant prosecutor. So I was also the attorney for the county juvenile office. It killed me that there were kids that didn't have homes to go to for Christmas. So my wife and I became foster parents and have adopted three beautiful kiddos. We've also had a biological child. So we got four little ones. It's kind of a soft Tampa 2 cover zone defense, kind of bend, don't break, keep everything in front of you around my house.
Sure, yeah. I mean, I think it's from what I've heard from parents, having one is a problem, and then two is at least they can entertain each other a little bit, and then three introduces some pretty interesting dynamics into the group. Has that been your experience?
Yeah, and then the fourth one, it's like imagine if you were drowning and someone tossed you a kid. That's kind of like with the fourth child.
Oh, that sounds awesome.
Getting to be a dad's the best thing that ever happened to me. I got a real heart for making sure that Missouri is the safest state in the nation for children. And so I think, folks will see that in so much of the work we've done.
Sure. That's not the case in a lot of jurisdictions across the United States. For some reason, this idea of harm reduction, which you can probably explain better than I can, but it is a juris policy that I don't know where it came from originally. I mean, I know there's some Marxist background to it, but I don't know where it came from in the U.S. originally. But it's pardon me for saying so, but the dumbest shit I've ever heard of in my life. So tell the audience what harm reduction is as a concept.
Well, as a concept, what I see all too often is that you've got policymakers who are more interested in a woke ideology than practical good. And when they're putting that ideology ahead of practical good, people get hurt in the process. You see that when you have prosecutors who aren't enforcing the law. They think somehow we're going to fix crime by not holding people accountable for their wrongdoing, or that the rules don't matter. You see that in the context of some of the transgender mutilation that's going on against children, where the adults in the room that are supposed to be making sound decisions are ignoring the lack of science or medicine to back up some of these dangerous life-altering procedures, and kids suffer as a consequence.
And the concept of broken window theory is decades old now, 50, 60 years old, I think, although in concept it is quite a bit older than that. And then defensible space theory. I mean, my master's degree is in international homeland security, but I have a background in domestic security as well. And this is all like standard stuff, right? Like if you talk to anybody that's worked in the risk management or security fields over the past 50 years or so, they're all going to tell you the same general stuff about how to keep communities safe. It's all pretty standard. It is community awareness, community policing, broken window theory, and then punishment, right? And then true rehabilitation, not the way that we do it in America. We incarcerate people. That's not the same thing as rehabilitating people. But these theories on crime and punishment have existed for quite a while, and yet we've taken this bizarre turn in the opposite direction. And it's like, I guess some people call it suicidal empathy. I think that's what Gad Saad calls it, which is, it sounds right to me. But from your perspective, how has that played out? Because you're an attorney general of a state now. So how's that played out on your watch, I guess?
Yeah, the rule of law matters. I mean, we used to elevate the rules of the game above the players and the outcomes, and consistent, clear, equal protection under the law, consistent application of the rules. These are concepts that serve rule of law principles, and the left in America has abandoned those. And it's almost like this infinitely regressive death spiral. I don't think they desire anarchy, but I think they want to create enough chaos to justify totalitarian control. And you see that with the public bemoaning of institutions that have timeless principles of freedom and liberty, and institutions that have served to protect freedom and liberty for over 200 years. Look at what's happened most recently, where you've got legislative leaders in the United States Congress calling for the impeachment of the United States Supreme Court and trashing the judicial process, a third, co-equal branch of government, because they don't like the application of the law to facts that are in front of them today. And again, that means they've rejected rule of law principles. That means they've rejected an elevation of the rules of the game above the players and the outcomes, because they're so desperate to retain power. And I think COVID really brought out the worst of the worst in kind of the despotic tendencies in the left. And they showed the left that if you can justify tyranny or despotism through some perceived emergency, then you can get away with whatever you want, and the rules don't matter, and separation of powers don't matter, and people can be herded into these silos and controlled, but not only their thoughts, not only their actions, but also their words and thoughts controlled. That's dangerous. That is antithetical to who we are as an American people. I stand for the proposition that the rights that we see in the Constitution come from God, not man, and that the Constitution is intended to protect us from the government, and the government exists to protect our rights. And I think we have a fundamental disagreement on those general principles with the left today.
Yeah, that's a problem that some amount of people believe that rights are conferred upon them by a state organization, which is nonsense. I mean, I'm pretty sure you could just read any of our founding documents. Not one of them says that the state should have control of this stuff. And look, things change over time. Maybe they've changed their mind that they want to be in a situation where they get governed harder, right, by whomever it is. And it's very bizarre to me. It's taken a drastic turn even in the last 20 years. We went from fuck you, don't do what they, or fuck you, don't do it, or I won't do what you tell me, to fuck you, do what they tell you, right? And in a matter of one generation, it's wild that it happened that quickly. But to your point about instigating control, it does seem like this is some kind of social security space vertical integration where they're trying to create the conditions wherein erosion of liberty would be preferable to liberty itself, because people don't want to accept the responsibility for it, right? Because there is responsibility when it comes to liberty. That's why Franklin said a republic if you can keep it, right? I mean, there is a responsibility to this stuff, and I don't think that the average American understands that. They're comfortable in their suburb. They're comfortable with their Hot Pocket and their iPad. And they look around and think that everything's just going to work out. Well, this laissez-faire stuff has never worked in all of human history.
Yeah, I think I live by 3 irreducible axiomatic principles that have served me well, and I think reflect where we were as a country several years ago. Number 1, I am not a means to someone else's end. I'm an end unto myself as an individual. Number 2, freedom is a zero-sum game. More government, less freedom. And number 3, with rights come responsibilities. I have the right to vote. I have a responsibility to get up, drive to the polling place, be educated on the issues, and cast my ballot accordingly. And so those are kind of hard truths these days, and they shouldn't be. It's objective reality.
Sure, yeah. I mean, some civics classes would be nice. We don't get into specific policy too much in this show. It's more theoretical, I guess. But we can talk about we can talk about the Trump immunity thing, because that's not really what it is. That's what it's called because that's what the immediate impact of it is. But in reality, presidents in official capacity have always had qualified immunity for their actions, which is to say other politicians can't frivolously attack them legally just because they disagree with their policies, because that's not how that's supposed to work. You get elected, that's your 4 years to enact whatever policy you want. Yeah. Nothing changed yesterday in that regard.
That's right.
All that happened was it got sent back down to the lower court to decide what is and isn't an official act with regard to his behavior. And that's always been the case. I mean, you as a military officer know that giving an unlawful order to one of your soldiers is an unofficial act, because official means an official capacity, and anything that's not lawful is outside of your official capacity. I don't want to play fucking word games here, but what are we talking about?
Yeah, I think you're absolutely right. The Supreme Court just restated something that we always knew and was always true and present in the law. It was self-evident if you look at the text and structure of the Constitution, in the sense that to the extent the president is supposed to be sanctioned, the founders contemplated that and built a methodology by which he could be sanctioned. It's called impeachment. But at the end of the day, the Constitution grants the executive branch broad and somewhat vague authority with the intention that the president have the latitude to meet any exigency, foreign or domestic, and have the latitude to enforce laws enacted by the Congress. It's kind of like, if you take it back to military terms, you've got your 5-paragraph op order, but you've also got your commander's intent. And at the end of the day, go take the hill. How you get to the hill and how you take that hill is up to you, but take the hill. That's the commander's intent. Same thing with the Constitution. The intent of the framers was that the president would have the latitude to carry out the laws and meet exigencies even when Congress wasn't in session or he didn't have explicit authority, and thus he has to have some level of immunity to carry out those official duties.
Yeah.
And look, sir, what the screaming memes on the left are saying, that, oh, well, the president can just assassinate people. Well, no, it's not a core function of the presidency to assassinate someone. That on the other hand, to the extent he has to make tough decisions about how to conduct a strike to eliminate a terrorist threat, he's absolutely authorized and protected to make that decision.
Well, there's only been one president in American history that I know of that's drone striked American citizens, and that is Barack Obama, right?
That's right.
Which is interesting, and it plays into this whole calculus. I think James Lindsay calls it the iron law of woke projection. Anything these people accuse Republicans of doing, they are not planning to do. They're already doing it somewhere, right?
Yeah. Well, and that's what's dripping with irony. Like, Joe Biden should be out celebrating this decision, because now it prevents red state attorneys general and prosecutors from prosecuting him for aiding and abetting in human and fentanyl trafficking across our southern border.
Yeah, well, I don't know that he knows where he is, to be fair. And I think that's a pretty safe thing to say. And then the other thing that happened recently was the Chevron decision by the Supreme Court. And it's another one that's being cast as some kind of right-wing extremist idea. It's like, this is just the balance of power. Here's what the Constitution demands. The legislative branch makes laws. The judicial branch adjudicates whether or not those laws are constitutional, and the executive branch applies those laws as written. That is the standard of the Constitution. So Congress still has the ability to consult with all these so-called experts in the executive branch and these agencies before they write laws. As a matter of fact, they can hire private consultants, which they often do on both sides of the aisle, right? Americans for Progress on one side, and whatever the Koch brothers pack is on the other side, have written model legislation for 25 years now, if not longer, for one side or the other. And I don't particularly like that, but that is a legal thing that can still happen today, right? So you can get the information from experts, and I don't understand, like, Congress, these people who are megalomaniacs in a lot of regards, want to subjugate themselves to something else. I mean, that's what, like, subjugate their entire branch of government to the executive branch, right? But then call the guy who's standing up against it a potential king. It's very mind-boggling to me.
Yeah, you're right. I mean, this is a decision that reinforces the separation of powers doctrine present in the structure of the United States Constitution. And the founders understood that diffusing power over 3 co-equal branches of government was essential to maximizing liberty and was a bulwark against a slouch towards a centralized tyrannical government. I think part of the problem is that in law school, you never look at the structure of the Constitution. In your con law class, you kind of speed through as many of the articles as you can, and then there's separate classes for First Amendment. Maybe you get a Second Amendment class, although not usually. There's an Eighth Amendment cruel and unusual class as it relates to conditions of confinement. There's usually a criminal procedure class, and then a civil procedure class. But you never stop and look at the structure of the document. And there are rights present in the document. And again, those come from God, not man. And the document is merely intended to protect us from the government encroaching upon those rights. But the structure is also intended to protect those rights, both enumerated and implicit, but not explicitly detailed. And so that structure matters. And I think a rejection of the Chevron doctrine is the appropriate role that the judiciary plays, which essentially says, the judiciary interprets what the law is, and there is no sanction in the Constitution for a fourth unelected bureaucratic branch of government with lawmaking, law enforcement, and law adjudicatory authority.
I wonder how many law students have read all of the Federalist Papers, for example, right? Which are, you can kind of think of them as a debate, right? Because Hamilton and others are trying to convince the people, I guess, by the people, you can define what that really means, but trying to convince the people of one thing or another, right? There's some talk of a central bank. Everybody says no to that, although Hamilton really wanted it. He wanted a king in all but name only. Frankly, not a big fan of that dude. They should have picked somebody else to do the rap movie about, or whatever the hell that was. But I wonder how many law students have read that. I wonder how many have read The Preceptor, which is a textbook from the middle part of the 18th century. That if you read it, you'll see almost everything you find in the Declaration of Independence and the Constitution. It is a very good summary of English common and case law up till that point, and not just the law, but the theory behind it. And then, of course, the two treatises of government by Locke. There's a lot of different books that are probably outside the curriculum that seem like they would be like, people are deciding our future without understanding our past. That seems like a very large problem.
It is, and I think the most frustrating part of all of that is not only that we've forgotten the historical context that provides the backdrop for so many of our foundational principles and doctrines and documents, but also that there's this attitude of inconvenience that, look, I can't be inconvenienced by how difficult it is to get a bill through Congress. I can't be inconvenienced by the Supreme Court rejecting an unconstitutional student loan bailout. Or that in order to respond to COVID, we can't be inconvenienced by constitutional protections for individual citizens. Those are timeless principles of freedom that are codified in the Constitution. Let's take the First Amendment, for example. The Biden administration has argued that they have to be allowed to censor speech to protect Americans from disinformation, as if the government has some role in telling us what is true and what isn't. The government has no role in that. The founders would have understood that the First Amendment protects a free, fair, and open marketplace of ideas, where the competition of ideas, like the Federalist Papers, would lead the people to determine for ourselves what is and isn't true. The remedy in this country for disfavored speech has always been counter speech, not government censorship. But yet the Biden administration has rejected that principle in favor of censorship on big tech. And the media has been collusive in that relationship by not covering the facts accurately or fairly. One wonders if the media would be so collusive with the Biden administration if they were the ones who were being censored. But again, these are timeless principles. It doesn't matter that in 1700 it was a printing press, in the 1900s it was radio, in the 2000s it was the internet, and now it's big tech. The principle remains the same, which is that the people are free to speak and hear what they please, absent government censorship.
And where do you think the red line is vis-a-vis censorship on social media? Because technically they are private companies, even though some of them are publicly traded. Still private companies in the sense that they're owned by the shareholders, right? So where is the red line exactly? Because here's something, and I'm sure, I would imagine you would know this probably from getting your guard license in Missouri back in the day to be a guard at the courthouse. Even if you're not an agent of the state, if you're a private security guy, and a police officer calls you and tells you to do something unconstitutional, then that police officer has violated the rights, third party of whomever's rights you violated. That is a fact, right? You can violate somebody's Fourth, Sixth Amendment rights, all kinds of stuff, just by doing that. I don't understand how it's different. Like I think the majority opinion for this government censorship case suggests that the companies have a First Amendment right to do whatever they want, right? But that's not technically true if the government is requesting it of them. That to me seems like a pretty clear-cut case of censorship.
Yeah, that's right. And here it's not just the government. The evidence we put on, and I believe that the court relied on, at least in part of its ruling, was that there was more than just a request by the government. The government threatened big tech that if they didn't increase censorship, there would be immediate legal sanction against those big tech social media companies. And remember, big tech is a different marketplace than TV, radio, print because of Section 230 of the Communications Decency Act, which has created this impenetrable oligarchy of big tech companies that are immune from civil suit for the things that are said on their platforms, thereby removing kind of those open market impulses that would protect against censorship. And so the censorship that's going on at the government's demand absolutely violates the First Amendment, but there's a deeper problem here within that oligarchy of big tech as protected by Section 230 of the CDA. And the censorship that's going on, even within the private corporations, is inherently pernicious and nefarious, and is more dangerous because it's fundamentally reshaping this culture in ways that were unimaginable a generation ago. Where do you hide a dead body? On page 2 of a Google search. I mean, when Joseph Stalin shuts down a printing press, everyone knows about it. But when you're shadow banned, deplatformed, de-emphasized, you may never know it, and your listeners or your followers may never know it. And that's why it's so clandestine and nefarious, because you don't see it for what it is at the time it's happening.
So why do you think that the Supreme Court didn't find the government liable for this intrusion then? Because it seems pretty clear cut, and it also was effectively election interference.
Yeah, it absolutely was. My reading of that case actually provides a lot of hope. I think that the mainstream media's headlines are misleading and deceptive. At the end of the day, what the court said was that there was absolutely government censorship on big tech social media platforms as a result of this coercive relationship between the government and big tech in violation of our First Amendment right to free speech, but that the evidence we had adduced at that moment in time was limited to the years 2020 and 2021. Thus, the court sent us back down to the trial court to commence merits discovery. And the discovery process at this phase in the litigation will be much broader and more deep than in the preliminary phases of the litigation. Thus, we will have the opportunity to root out this vast censorship enterprise against the anvil of the precedent handed down by the court that this, in fact, is government censorship at its worst. Moreover, to those who would say, well, look, the censorship's ended, it was just a thing related to COVID, I don't think that's true at all. I think COVID, again, was the Trojan horse that got the enemy behind the gates. Show me one example in history where the government has ever infringed upon people's rights and grown and then retracted and restored rights on its own without being compelled to do so. That never happens. Government grows in a vacuum, and it's been sitting in a vacuum while this case has been pending at the United States Supreme Court. That's why I'm so excited to get back down to the trial court level and use the tools of civil discovery to continue to root out the vast censorship enterprise and build a wall of separation between tech and state. I think we're going to learn a lot in the coming days, weeks, and months as we begin to roll back that curtain and understand the practices of the relationship between the government and big tech.
Sure. What you talked about inconvenience with regard to passing laws, we would call it red tape, right? And people want to get that out of the way. There is something to be said about checks and balances. A lot of this so-called red tape was specifically designed to ensure that the federal government remains ineffectual, right? I mean, that we did that on purpose. It isn't to it wasn't just to be a dick. Like, there's a reason for this stuff, because we didn't want a strong central federal government. That's why federalism exists. How do you think we can shrink the size of the federal government? Because you mentioned the bloat recently, and it's been going on for some time now. And it isn't something that lifelong Republicans can blame on anybody but themselves, frankly, because the largest expansion of the federal government in history happened on the neocon Republican watch. With the Patriot Act and the security state, and also the Department of Homeland Security, which shouldn't exist. So I wonder, from your perspective, how do we shrink this stuff now?
Well, let me start by demonstrating one of the principles you just mentioned, which is that, there's this attitude of, the Constitution or the bulwarks that prevent tyranny are inconvenient to getting things done. That was on display in the oral argument in the case Missouri v. Biden, when Justice Ketanji Brown Jackson looked at the government and at our side and said, well, look, isn't the First Amendment here really hamstringing the government's ability to respond to COVID? Well, yeah, of course it is. That's the whole point. But like, we have a fundamental disagreement about why we have a constitution and why we have a government with the left. I mean, obviously she does not understand the original meaning and protections guaranteed by the First Amendment. But to your point, I think that first and foremost, we've got to slash and burn the alphabet soup of federal bureaucratic agencies. I think Chevron is the elimination of the Chevron doctrine gives us the green light to commence that process. If we need laws passed to mitigate against danger, Congress should pass a law and the president should sign it and then enforce it. But we don't need an army of unelected bureaucrats interfering with our daily lives and our liberties. Again, it's a zero-sum principle: more government, less freedom. Start repealing, rescinding, slash and burning that alphabet soup of the bureaucratic state at the federal level.
Sure. And there's a multi-head monster that goes on here. One is that government is, always going to eventually become even if it doesn't begin that way, which usually it begins that way as well, but it always eventually becomes a vehicle by which to extract labor and wealth from the population, right? That is why we've set our government up in such a way that it's from the bottom up, and there's recourse against any kind of federal central authority. Now you've been working on some of this stuff, and then one of the other parts is using that extracted wealth to either make yourself wealthy or to purchase power, right? And purchase power in this case means purchase votes. And that's what the welfare state has been for a very long time. Finally, I think social media has been a big advantage to this, and then some leadership on the part of some prominent black Americans. But black people are starting to finally wake up to this stupid bullshit and be like, nah, I don't think that, like this, you can only trick me so long. Now I see a guy up here that's basically a mummy. And also my neighborhood still sucks. So what exactly are we doing here? But that's the other thing is buying votes. Now, you've worked on a case directly related to this recently and won, which is the so-called student debt relief, which really is just a reappropriation of wealth from one group to another, from a group that are blue-collar workers with a lower average annual income in a lot of cases to higher average annual income people, which seems like reverse Robin Hood to me, right? But it was directly targeted towards young people to buy their vote. That's all that was.
Yeah, President Biden feels himself slipping in polling in a key demographic with younger voters and is attempting to illegally, unconstitutionally buy off that voting bloc by taking money away from working families and giving it to Ivy League elites and intellectuals. I mean, it's really a subsidization of the status quo, and a dangerous one at that. We defeated President Biden's Plan A at the United States Supreme Court 1 year ago this month, and just a week ago defeated his Plan B with a nationwide preliminary injunction at the U.S. District Court level. Congress has never authorized the president to redistribute that much wealth. Certainly, Congress has the power of the purse, not the president. And the Supreme Court, in its first decision, determined that absent explicit authority from Congress, the president had no authority to act in this manner. Congress has twice rejected such a bill, once in 19, again in 2021. Thus, Congress, since the Supreme Court handed down its decision in 2023, has not passed any new authorization to the president. He knows it's wrong. This is a constitutional crisis. I mean, when you got the president on the stump bragging about his willful defiance of the United States Supreme Court, that's dangerous. And yet somehow the other side is the threat to democracy. I don't think so. People see this for what it is. And I'm not going to let Joe Biden saddle working class families with Ivy League debt.
Yeah. Well, I appreciate your efforts in that regard, because you and I paid for our college education with blood. So they can go fuck themselves, frankly. Not that you have to co-sign on that statement, but I certainly believe it.
We both have friends that didn't come home, right? I mean, what are we going to tell their widows and their families? Like, hey, I know this is how your loved one paid for college, but now Joe Biden's handing it out for free. Like, it was a privilege to get to lead soldiers in combat and in the Army. You know, I'm proud to have been able to do that. It was a great way to pay for school, but it dishonors the memories of those who served and used this as a method to pay for school, and it dishonors those who chose an alternative path, who didn't go to school because they had to get to work and couldn't afford it. It dishonors all of that in favor of trying to illegally, unconstitutionally buy votes. Biden and his ilk should be ashamed of themselves.
Yeah. Speaking of the power that Congress has, I want to pivot a little bit, since you and I both have some experience in this. Congress hasn't declared a war since World War II. Yet we've been in war for 40, I think, out of the 70 years since then, 70-some years since then. Is there any hope of reining that back in? I mean, Eisenhower warned about this bullshit, right? And to be frank, the Constitution doesn't authorize a standing army in the first place. It authorizes a Navy and a ground force attached to the Navy to protect shipping and transportation. I think it would be reasonable to add the Air Force into that at this point, because they didn't know that planes were going to exist, and shipping and transportation also happened there. But as far as having a 1 million-man standing army, I don't see how that's a thing. What's the purpose of that? I mean, frankly, I think the Army should be rolled up into the Marine Corps and used in that way, frankly, and save us quite a bit. I mean, our biggest expenditure every year is defense.
Yeah. Well, and why aren't we using that defense force to defend our southern border? I mean, isn't that the reason we have a military is to defend our national sovereignty?
Mm.
Isn't that not national sovereignty being violated at our southern border? And instead, what you see is a military that's turned into a petri dish for woke experimentation. They would rather promote abortions and transgender mutilations on military bases and in military hospitals than actually protect and defend the United States of America. I mean, it's a shameful nadir of depravity that we've reached under Biden's watch, and it tarnishes the legacy of some really great institutions that used to teach personal accountability and responsibility and be, again, a bulwark against tyranny and despotism.
Yeah. Now, with regard to defending the southern border, technically, I don't know where this would fall because would you consider that a police action or a military action? Posse Comitatus in 10 U.S.C. 275 would prevent any of the current branches of military from operating in a police function domestically. But
Yeah.
I mean, you could call that a military function. Frankly, I think defending the border, defending the homeland would be a military function, I believe.
I agree. And I think what you see when you've got illegal migrants who are surging at levels that they're overrunning concertina wire and barrier systems, overpowering border patrol and customs agents that are there stationed at the border. It's an invasion. It's no longer like just one person slipping through under a wire or something. I mean, you've got actual instances of aggression by a massed group of people against the law enforcement apparatus that's there to prevent their entry. And all of it is President Biden's fault. And again, it goes back to what we talk about, like clarity, consistent application of the law. What he's done is pervert the law when it comes to immigration in order to hang an open sign at our southern border. And that has invited people to undermine the rule of law. If they don't think it means anything because they think he's welcoming everybody in, then they're more than willing to amass at the southern border and overpower border patrol and customs agents. And that's dangerous at the southern border, but it's dangerous everywhere else. It's turned every state into a border state. In Missouri, we've had more than 1,500 deaths in 1 year alone from fentanyl exposure. We've had more than 1,100 incidences of human trafficking that are reported. What about the ones that go unreported, uninvestigated, unprosecuted? So these are real human tolls that are directly attributable to the Biden invasion at the southern border.
Yeah, I mean, by the way, it's not just illegals crawling over concertina wire. In a lot of cases, they're walking through concertina wire that's been cut by federal agents at the behest of Mayorkas and Biden. I think we need to have some discussion, some reexamination of the supremacy clause, right? I understand why it would exist. I understand that, should something get the necessary votes to pass at the federal level, that would make a lot of sense for the supremacy clause to be a thing. But this is all tangled up in this Chevron decision, whether or not executive branch agencies can just make their own policy and stuff. And the president does have some leniency with regard to non-earmarked or discretionary spending in that regard. But as far as setting policy that affects the country in a legal sense, that has to fall back to Congress, one. And the supremacy clause, should it interfere with a state's right to defend itself, cannot be the chief decision maker there, I don't think.
Yeah, I think, the number one, I hear the federal government trumpeting the supremacy clause in every case we have against the federal government as if the supremacy clause means they're supreme and can do whatever they want. That's not what the supremacy clause is for. It's a tool of interpretive methodology. It's when Congress has validly enacted a statute and there's a conflicting, irreconcilable state statute, then the federal statute prevails. But again, that only happens when there's a direct conflict and it's irreconcilable through judicial interpretation. The 10th Amendment is actually a stronger fount of legal authority for the principle that any authority not given to the federal government or denied to the states is enjoyed by the states and the people of the states. And in celebration of that 10th Amendment principle, the state of Missouri enacted the Second Amendment Preservation Act, intended to protect our right to keep and bear arms, to defend ourselves, our property, our families, our loved ones, and to prevent, again, act as a bulwark against a tyrannical government. But it's as much a codification of the anti-commandeering doctrine from the 10th Amendment as anything else, because it stands for the proposition that the federal government can't order state law enforcement apparatus to carry out unconstitutional Second Amendment restrictions. So it actually only limits state officials, not federal officials. Yet, despite all of that, the federal government has sued the state of Missouri. They hate this law. but they're more concerned about what it says than what it does. And they keep trumpeting this idea of the supremacy clause as their legal justification. And yet they don't have standing because they can't show how they were harmed. They've not been limited in any way, shape, or form. I think ultimately that case also lands at the United States Supreme Court and will reassert our system of federalism and reassert the anti-commandeering doctrine found in the 10th Amendment.
Yeah, I mean, there's other. Well, see, that's a really interesting conversation because the supremacy clause is in the Constitution, and the Constitution is amended by the 10th Amendment. So why does the supremacy clause always come out on top in every case that happens at the federal, district, or Supreme Court level? I don't understand that. That seems completely backwards to me, right? I mean, you wouldn't appeal to the Constitution over any other amendment.
Yeah, totally. And I also think that all too often the supremacy clause is just an excuse to exercise authority not given to the federal judiciary under Article 3. I think there are ways in which you can synthesize state law and federal law so that there's not this irreconcilable conflict. But yet too often you've got bureaucrats like at the DOJ who are just upset that the state legislature would ever assert any kind of sovereignty for the state of Missouri. And they then file suit and find a judge, a federal judge who is insulated from the electorate or from any kind of sanction that's willing to go along with this idea of dominant federal power.
Yeah, and then pivoting to the Second Amendment, since we brought that up, there have been a number of cases decided recently, Heller and others, that aren't being applied at the federal court level. They're being the lower courts are thumbing their nose at the Supreme Court rulings, and I don't understand why that's possible. Is this a normal process of clarification of something, or is this lower court rebellion?
Yeah, I think you've got lower courts that are naturally predisposed against this kind of original understanding of our rights. I think it's also important to remember, at the time of the founding, and the time of the adoption of the Bill of Rights, the Bill of Rights only limited the federal government. They didn't actually apply to the states. It wasn't until adoption of the 14th Amendment after the conclusion of the Civil War that those rights guaranteed in the Bill of Rights then were incorporated against the states. So no state could abridge those rights as well. And so the original understanding of those rights, there was kind of the four-box theory of rights. You had the right to the pulpit, the jury box, the ballot box, and the tinder box, the right to serve in the militia. And the soapbox, tinder box, jury box, and so the four-box theory of rights. And then those were political rights. And then you had a separate subset of civil rights. And those two concepts became conflated and intermingled after enactment of the 14th Amendment. And so I think that it is absolutely true, especially within the context of the ratification and adoption of the 14th Amendment, that the Second Amendment protects an individual's right to keep and bear arms. And the Supreme Court has adequately and accurately decided that issue. But there are still federal judges who are predisposed against that because, again, it's not safe. They ignore the irreducible axiomatic principle that with rights come responsibilities, and that the founders would have tolerated a certain amount of risk in exchange for the liberty given to us by God.
Yeah. So why hasn't the Supreme Court done something about this? Because Heller is quite clear that an individual has a right to possess a firearm regardless of whether they're in an official militia or not. Right. Bruin justifies that the government must demonstrate why somebody shouldn't have a gun versus the other way around, which was the case in New York, Massachusetts, and California with the good cause regulations and all that bullshit. And that was the Bruin case. So these two cases make it quite clear that owning a personal firearm without a permit is a legal act, and that the government can't tell you, like, so California still has this handgun list that they publish every year, and you can't buy one that isn't on their list. That's completely unconstitutional, but yet it stands, and nothing happens. I don't understand why the Supreme Court doesn't look at a case that they've already adjudicated and say, hey, you guys are applying the law incorrectly. Do they not? I don't know how that works, to be honest.
Well, first and foremost, it's just a nature of the judicial process that there has to be an aggrieved party who then brings a case or controversy before a federal court that ultimately appeals that decision all the way to the United States Supreme Court. And that's a tedious, time-consuming process. And that oftentimes what I see, and I think you see this in a most recent decision from the United States Supreme Court as it relates to New York's attempts to essentially vex, harass, and delay individual firearm ownership, that the court gets frustrated when they see chicanery at the state level intended to subvert judicial review in the appellate process in the courts. You saw that kind of bubbling to the surface in that most recent decision out of New York by the United States Supreme Court. I think that'll be true when and if a case from California reaches the Supreme Court. I think we look to the Supreme Court as the authority to solve problems, but we have to remember that they're umpires. They can only call the games that are brought in front of them. They don't get to bring the cases. And so finding aggrieved parties, one of the things I've been talking about that I think it's high time we have a serious conversation about. I agree with the principles of a party, under Article 3 has to have a case or controversy in order to seek federal court review. And one of the jurisprudential concerns is that there be standing, an actual party with a concrete cognizable harm traceable to the action of the defendant. I get all that. But I also think that in the context of when states are bringing claims, that perhaps it's time to relook that standing analysis and give more deference to states to be able to protect a broader spectrum of rights and a broader category of individuals' rights than kind of the more traditional rigorous jurisprudential standards that are applied to traditional standing notions.
Well, if I create an organization, LLC, or a class action lawsuit, and I'm an attorney, then I'm representing the will of all the signatories. You, as the Attorney General of a state, are representing the will of every citizen in Missouri. I don't understand what the difference between those two things is.
Yeah, no, I think that's exactly right, and really, again, emphasizes the point I'm making. I mean, at the end of the day, unfortunately for California, but fortunately for me and my family, I'm not moving there to become an aggrieved party because I'm not surrendering my liberty to the tyrants in California.
Yeah, that is a good thing for everybody. And then, the 2A, regardless of what's happening in the lower courts right now, are on a pretty good run. Heller, Bruen. It's been going on for about 14, 15 years now. I guess Heller was originally 2008, so quite a bit longer than that, actually. Yeah. More recently, we've seen these challenges at the Supreme Court level that all kind of fold into the Chevron decision. I don't think that it should have been surprising to anybody that it went the way it did. The first one was in 22 with the OSHA regulation that was going to demand everybody get forced vaccinated. Obviously, they decided that an executive agency doesn't have the right to pass laws. And then pistol brace, and then bump stock, and then Chevron. These are all the same case in principle, right? And it is that Congress's job is to pass laws. And if you can't get the votes, then the law doesn't get passed. You can't turn people into felons just with the stroke of a pen. Now, some people are upset with the Rahimi case right now. They think that the Supreme Court that was on a run has kind of abandoned them now. The Rahimi case deals with the so-called assault weapons ban in Illinois. I don't know what an assault weapon is necessarily. I mean, that's the dumbest shit I've ever heard in my life. But what the court actually did was return that case to the lower court so that they can re-adjudicate it. So I wouldn't consider that a loss just yet. There's new information that is now available. So the assault weapons ban, the Rahimi case rather, is the one where I think it upholds the Lautenberg Amendment, which you probably had some experience with in the military, because a lot of people, you get charged with domestic violence, you can't carry a weapon on duty. That's one version of it. The other version is not of the Lautenberg Amendment, but another version of this outcome is that if somebody has a TRO against them, like a temporary restraining order or something like that, that it is constitutional if the court can prove they're a credible threat to somebody else, that they can temporarily disarm them until it's adjudicated. The assault weapons ban got returned to the lower court today in Illinois because they want the lower court to reevaluate it based on the Rahimi decision as well, and put that into both sides, I guess, put that into their amicus. Can you explain how that works? So sometimes a case gets kicked back down to the lower court because of, well, your standing wasn't correct. And I think this is the way I explain it to people usually, but I want to know if I'm right or not. The Supreme Court will return something to the lower court to make sure they get it right, so we don't end up with Roe v. Wade again. Roe v. Wade was bad case law, right? They didn't do it the right way. They used bad precedent, and here we are years later, and it got overturned because it was bad precedent. And I don't think anybody wants that to happen, especially when it comes to a constitutional right.
Yeah, I think that's right. Look, Roe was wrongly decided because nothing in the Constitution gave the federal judiciary the authority to regulate abortion. They were just making things up. That's left to the states, and so Dobbs accurately corrected that. I think Roe was also fundamentally unconstitutional because it deprived due process to a living being inside the womb. So I think that again, these are issues that have been returned to the states properly under the Dobbs decision. I think that when you're talking about bad precedent, that's probably Exhibit A in some of the worst precedent ever in the history of the United States Supreme Court. And the court wants to avoid making bad law. And so the court wants to ensure that it has the facts necessary upon which to issue a ruling. And if there's a new decision that says, well, there's 3 prongs in the analysis, you only sent up 2 pieces of evidence, and so thus we have insufficient evidence to analyze that 3rd prong in the analysis, we're sending it back down for further findings as to that 3rd prong. It's more just a, hey, show more of your work before we can grade out your performance. And again, the objective being to avoid bad case precedent based on incomplete information.
Sure, yeah. I mean, it makes a lot of sense to me. Like, you don't want to do things the right way, you know?
Yeah.
Ultimately, that's what we should be doing. Speaking of doing things
Process
the right way,
matters.
yeah, process does matter because it's going to be the lens through which every new case is going to be viewed, and every new case is going to be a little bit different, right? Every new case adjudicated is going to be different, so the standard has to be immovable. It can't be a floating target somewhere, and because then that just allows for activist judges down the road to misinterpret on purpose, and why would you want that?
Yeah, and again, those principles of clarity and consistency it ultimately serve the rule of law.
Speaking of doing the right thing, I want to talk, before we get out of here, I want to talk about the crime bill a little bit. Now, I'm kind of back and forth on it because certainly we had a big problem, and getting shitheads off the street is something I'm in favor of. Leaving a full generation of young kid without dads and doing nothing about that has caused us exponential problems. We clearly fucked that up, right? So we got that. This is what America does. We go to Afghanistan and root out the Russians, and then we let the Taliban take over. We over and over. We do the same thing, whether it's foreign or domestic policy. We fucked that up badly by not stepping in the breach and taking care of those kids. Now, you did to some degree, right? Go find kids that need help and bring them into your home. A lot of people do, but the country itself didn't do this. So I wonder, I know this is kind of just a thought exercise, but if it was 1995 and this is going through the courts, going through Congress rather, how would you change, or what would you add to the crime bill, I guess, to prevent that from happening?
Yeah, I think that each case needs a fact by fact analysis and determination. And when you're limiting judges' discretion and you're kind of creating this pre-programmed choose your own adventure, you're limiting the range upon which those facts can influence outcomes. And so I think that's problematic. I think that, there are categories of criminal defendants. There are those who they just had a bad day and are going to course correct on their own, and any amount of sanction is going to wake them up and they're going to fix the problem. There are those who are addicted to controlled substances, and the only thing that's going to change their behavior is actual treatment that eliminates that addiction problem and thus reduces that criminogenic behavior. And there are those that are just committed to crime. And so you've got to be able to categorize appropriately and efficiently and have objective metrics to do that in order to tailor the remedy on the back end to the wrongdoing on the front end. And I think that too often we've failed to accurately identify why we have a criminal justice system in the first place. And a recalibration is appropriate at that instance.
And I wonder from, like, let's say this was an issue in Missouri, your role as the Attorney General, how do you handle the fallout as well? So definitely mandatory minimums and things like that, I don't think serve any purpose. I mean, what's the point of even having a judge? Just get a robot up there. You know what I mean? But then there's the fallout, right? So there's the fatherless homes that are poverty used to be the #1 indicator of potential criminal activity. Fatherless homes has now doubled that in rate. So I wonder how, like, from a community perspective, we talk about rights and the responsibilities associated with them. We do have the right to police our states, our cities, our counties, whatever, our country. We have the responsibility to take care of people who can't take care of themselves as well, especially children. And we have failed mightily as a country at that over the past 30 years. I mean, it's one thing to say, well, everybody should just go, do what they can. But we need something a little bit more concrete than that, I think.
Yeah, I think first and foremost, you look at state foster care systems. There are too many kids in foster care that are languishing on the vine. We know that the outcomes for foster kids nosedive the longer they stay in care. So those kids need permanency. They need loving forever homes. And so at the 12-month mark, they either need to be reunified with biological families, or there needs to be a termination of parental rights and the kids put up for adoption so they can find that forever home. And I think that'll reduce some of the problems on the juvenile court level. I think that ultimately, again, when you're saying that people aren't responsible for their own behavior and the government's going to come in and take care of you, that is incorrect. That is antithetical to who we are as human beings. That's antithetical to who we are as Americans. And so re-injecting personal accountability and personal responsibility into our communities is really essential. I got that in the military, right? I mean, you saw that in the military. It used to be one of the last institutions that did that. There used to be community pressures from church, from work, but now people don't go to church. People don't even go to work anymore. And so those basic the kind of community standards have been eroded to the point that you get these fatherless homes, which results in a cycle of poverty and violence. And so rejecting personal accountability and personal responsibility into our communities, I think, is essential.
Yeah. We don't do A to C very well because we don't understand it. I think, A is we want safe neighborhoods. B is there's a threat to that neighborhood. And C is that there's a specific cause of that threat that we can interdict. There's an old security theory about this called Shaw's pathway methodology, and it's about how to interdict somebody before they become a criminal or a terrorist, right? It's like there's an inflection point in that person's life, a nurture inflection point typically, that predicts whether or not, because there are some people that are crazy and they're going to be criminals, killers, whatever, no matter what. Most people, though, are failed by themselves and those around them, particularly at a young age, right? And it isn't to erode personal responsibility. It's just like if we can find that point of interdiction earlier in life, and we know what it is now. We know that it's fatherless homes. We know that it is hyperactive young men who don't have any positive male guidance. We know that that's the case. Almost all crime is committed by males, especially violent crime. It's like almost all violent crime is committed by males. We know how to fix it, and we refuse to. It's kind of weird to me. But anyways, you're also running for Attorney General, which is unfortunately the case for politicians. You always kind of have to keep your eye on that next election. How's that going?
Yeah, it's going great. Look, I have no interest in being a politician. I want to be the Attorney General because I want Missourians to enjoy the same freedom, safety, and prosperity that I got to enjoy here as a kid. But what I'm up against is an East Coast elitist from New York who's been deposited here and a dark money group trying to buy an election and take a political office that rightfully belongs to Missourians. And so I would encourage all your viewers and your listeners, check us out at baileymo.com. I want you to go find somebody on election day and take them to the polling place with you. Again, it is an irreducible axiomatic principle that we have the right to vote, but we have the responsibility to show up and do it. And I'm going to expand that responsibility to say there's too much apathy amongst our generation, amongst gun owners, amongst those patriots who love freedom. We need to participate in the process. So find somebody, take them to the polling place with you, and make sure if you're in the state of Missouri, vote Bailey on August 6th to ensure that Missouri is not for sale to coastal elites with deep pockets and dark money groups.
Yeah, for sure. We've talked a bunch in recent weeks about the 10 million or so hunters that are eligible to vote that don't even register to vote in the country. It's like you would think with all the weird stuff going on in Colorado and Washington states, especially, to some degree Idaho and Montana as well, but mostly Washington and Colorado with regard to hunting and conservation and how they've tried to reintroduce predator animals and then outlaw hunting predator animals. Is like they don't understand how any of it works. They're literal experts in this field of conservation. They've not consulted. Like, if you don't think they're coming to your neighborhood, they are, man. It's just you can go to voteforamerica.org, by the way, and register to vote no matter what state you're in. And that goes to your point from before. If you got a buddy who's like, oh, I'm not doing that, it doesn't matter, kick him in the dick and make him go do it. It's like, well, if it doesn't matter, then what harm is it for you to go do it? You know what I mean?
Yeah.
Just go do it.
We need to show up and fight and win on one day, election day. That's it. Go find somebody you go to the range with. Go find somebody you have beers or drinks or dinner with. Go find a family member, a friend who you know doesn't vote. We can and we will take this country back if we energize and activate ourselves and get to the polling place and cast those ballots for freedom-loving patriots.
Yeah, and remember who your enemy is, by the way. They're people that want to take your guns away. It's George Soros, who's funding district attorney and attorney general races all over the country, including Alvin Bragg, for example. A lot of these people that are doing like inexplicable dumbass shit at the DA to AG level in law have been funded by people like him. So, I mean, like, if your enemy is... This is a good rule of warfare. If your enemy shows up somewhere to fight, they probably think that's an important place to fight, which means you should go fight them there.
Absolutely. This is a strategic objective that we have to secure for the health and safety of our nation and the next generation.
Yep. Well, look, sir, I appreciate your time today. Thanks for coming. Tell everybody where they can find your campaign websites and all that stuff.
Yeah, check us out at BaileyMo.com. That's BaileyMO.com. Love your support. Love to any Missourians out there to show up on August 6th and vote Bailey. And let's make sure we protect Missouri for Missourians.
There you go. And thank you for coming today, sir. Appreciate the conversation.
Thank you so much. Appreciate your time. Talk again soon.
Yeah. And thank you all for listening. This has been Citizen.